Good afternoon, everybody. Sorry about that, just some technical difficulties. I'm Madelena Viksne from Samfiru, Tumarkin. I'm an employment lawyer, and I'm here to answer some questions if you have any about employment law in BC or Ontario. I thought I would start off today just talking about the BC cannabis store fiasco that is happening here as a result of the um, job action that's happening, the labor dispute in the public sector. It stopped some of the province's distribution centers from shipping product and resulted in significant layoffs within that industry. So, for example, there's one company that has now had to lay off 90% of its staff because they haven't been receiving any deliveries. So I thought that I would just quickly touch base on what your rights are as a non-union employee impacted by these supply shortages and any layoffs. Um, Part of this depends on your employment contract. Your employer may have a provision in your contract that would permit them to lay you off. If that's the case, then you kind of have no choice but to accept the layoff, unfortunately. But without a provision in your contract that would permit a layoff, you are not, your employer can't lay you off without your consent, and your consent has to be express. So it would obviously be an absurd result if the situation was that your employer could lay you off based on implied consent, for example. Um, the fact that you don't show up for work means that you've accepted it. That doesn't make any sense. So, if you haven't provided your consent, your employer can't lay you off without it. And if they do so, then it's a constructive termination because they've reduced your pay and hours to zero without, any agreement on the part of the employee. So if that is the situation that you're facing, it would be worthwhile to speak to an employment lawyer and discuss your possible, you know, um, avenues for resolution in that situation. But yeah, so if you've been laid off without providing your employer with any consent and without any provision in your contract that would permit them to do so, um, it's definitely worthwhile speaking to somebody. Obviously, this is for non-union employees. Unionized employees are governed by a collective agreement and have to go through their union to file any grievances in regards to this type of thing. Um, so I have a question from Tim on Facebook. Can I be let go of my job while I'm on parental leave? You can't be let go from your position while you're on any protected leave under the Employment Standards Act, whether that's in BC or in Ontario. If you go on a leave, there is some confusion about what your entitlement is when you return. So, for example, for maternity leave, you're not necessarily entitled to be reinstated to the exact same position that you held before. Obviously, during the time that you're off, there's shifts and so on that the employer will have to make in order to fulfill their business obligations and business needs. What you're entitled to is to be reinstated to a reasonably comparable position or the same position. It's the same position, assuming that position exists and is available. In the event that it isn't, then it's a reasonably comparable role within the organization. Things like your pay and so on should not be changing. And your general work duties shouldn't be changing. You shouldn't be going from being a manager to being a janitor, for example, or from admin to a non-admin role. I couldn't think of an example there. But as long as it's reasonably comparable and the pay remains the same, they are not actually obligated to reinstate you to the exact same role. However, you can't be terminated during a protected leave. So if that is something, Tim, that has taken place, it would be worthwhile to speak to our office and get an opinion, or discuss your circumstances in particular. Unfortunately, as from YouTube, I actually can't answer questions relating to the union. I don't have an answer for um, your question about the variance. Um, my suggestion would be that you speak to your union rep. And if you're not getting an answer from your union rep, then try and escalate it within the grievance process. Um, Beyond that, uh, there's there's not really an answer that I can give you, as it's generally governed by your collective agreement, which is very specific to each union or employment situation. And so I can't speak to it sort of in this forum. Um, Now, Julie from Facebook has asked, can an employer change staff from salary to hourly pay? I mean, I guess this sort of depends on what that actually means for you. Are you experiencing a reduction in your earnings as a result of this change? If that's the case, my usual threshold is around 15 to 20%, is sort of where I draw the line for whether or not you could potentially, you know, argue that there's been a constructive termination that's taken place. Um, if it's less than that, I mean, I'm not saying that it's acceptable, but it certainly is more difficult to prove that it's a substantial change to the fundamental terms of your employment. Changing you from salary to hourly, though, doesn't necessarily reduce your pay. So it's a bit difficult for me to say, just based on that question, whether or not it would be permissible. If it's just a change in the manner in which they are providing you with the same amount of money, or there's no change to something like benefits or other entitlements, just based on salary versus hourly, then it wouldn't necessarily be unreasonable or unfair for them to make that change. Oftentimes, salary is tied to things like getting health benefits and so on. And if that's the case, and now your health benefits and extraneous compensation have been affected by the change, then certainly there might be a way in which it would be a breach of your contract. Um, but whether or not you're paid on a salary or hourly basis isn't necessarily the definitive point. It's more so whether or not your income has actually changed, whether or not your compensation, including other types of benefits, has actually been affected. And it's difficult for me to say just based on that question alone. Um, you really want to look at sort of the whole picture, the holistic picture, and also consider, why is it that you're concerned about a change from hourly to salary? If it's because there's a reduction in income, then it may be worth speaking to someone in our office to discuss what that looks like, and whether there is something that you can um, do about it, or to prevent it, or to reconcile it. Randolph from YouTube has said, my employer has given me a write-up for refusing to do an unsafe job. Can they now terminate me for cause because of this? No. Under the Occupational Health and Safety Act, which is in all provinces across Canada, you have the right to a safe and healthy workplace, free of hazards. And your employer is actually obligated, as your employer, to ensure that your workplace is safe and free from hazards. In the event that there is an unsafe work request, or there's an unsafe situation within your workplace, you have an obligation as the employee as well to report it. You're part of the eyes and ears of the company while you're working. So obviously, the ultimate obligation is the employers to ensure the workplace is safe, but if they don't know about a problem, they can't fix it. So they should be informed by you about the unsafe situation. In the event that it is such that you have actually refused to perform a job or do work as a result of feeling unsafe or identifying a hazard, and that has been disclosed to your employer, you actually can't, your employer can't terminate you for reporting a hazard or for a valid work refusal. Um, your work refusal should entail or should engage your employer to should engage your employer to resolve the issue, whatever the issue was that caused you to feel that you couldn't continue your position, continue your job. Um, and it's up to them to reconcile that or resolve that issue. If you are now facing consequences as a result of refusing to perform whatever job it was that you felt or identified as unsafe or hazardous and reported to your employer, such as suspension or hours being cut or even termination. That's called reprisal action, and it is not permissible. It's actually illegal under the statute. So if that is something that you feel is happening here, and your work refusal was valid and related to safety issues, um, I would absolutely suggest that you speak to a lawyer in our office to discuss what your options are moving forward. There may be things that you can do to either push the employer to fix whatever the issue is, or actually challenge something like a termination before the Ministry of Labor or otherwise. Um, you said here, just as an update, that they did send you home from your shift, but didn't pay out the hours you missed on that day. Your initial question was whether they could terminate you for cause. So I'm a little unclear on where sort of things are in the process of your situation. So I would suggest that you speak to someone in our office to sort of parse down into the details and give you some advice about whether you can or should, move forward in some way to deal with the reprisal that potentially exists here. Now I have another question from Facebook from Rena. Is it normal for an employer to pay severance without tax deductions? No. As a matter of fact, sorry, just to pause. S, you're correct. That's what I was trying to say. You absolutely have a right to refuse unsafe work. And if you're being punished for it in any way, whether it's reduced hours or pay or suspensions or terminations, that is illegal. So, Randolph, you should speak to somebody if you feel like that is the consequence that's being faced by you at this point. Sorry about that. So, Rena from Facebook asked, is it normal for an employer to pay severance without tax deductions? No, your severance pay is treated as income, just like any other paycheck would be. So generally speaking, your severance should be treated as any other paycheck. Obviously, it's often a lump sum. So if you're being paid with a lump sum, your taxes are going to look like they're significantly more. You're often going to get them back on a tax return at a later point because it may result in an overtaxing, especially if it, overshoots you for your regular earnings for a year. But in terms of how it's actually paid out to you, it's usually paid through payroll, and it's subject to the same tax deductions and withholdings as usual. The exception is if it's paid out as a retiring allowance, in which case it's still subject to taxes. They are taxes at a sort of sliding scale, sort of applied on a sliding scale. So 10% if under 5,000, 20% if between 5,000 and 15,000, and 30% if over 15,000. But the difference between a retiring allowance and just regular payroll is that retiring allowances don't don't have CPP or EI deductions taken in addition to taxes. But in any event, your severance it's normal if it's taxed as per usual. Um, and just make sure that you let um, your accountant know about the lump sum payment, as well as I usually suggest that people call EI um, to report their final lump sum severance payment over the phone, as opposed to trying to let them know that that's what it is via their sort of portals or online, because I think that there sometimes ends up being some confusion if you try and report it online, and it can be treated differently depending. From Kim on Facebook, what can I do to deal with the toxic workplace and being harassed by several coworkers and don't know what to do about it? Um, so the first thing that I'll say is that there is always a difference between harassment in terms of how it feels and harassment in terms of a legal standard of harassment. So that's just something that's important for people to just understand generally, is that, it can absolutely feel like harassment. It can absolutely be harassment. That can be totally valid. But um, what you could prove or what you could rely on in a legal context um, likely requires that it hits a certain threshold. And um, oftentimes it doesn't necessarily hit that threshold just, because somebody is treating you poorly at work. Whether that's wrong or right isn't sort of the argument I'm making. It's just something to consider when you're thinking about things like toxic workplaces. That being said, if you feel like you're being harassed by your coworkers, I'm sorry to hear that. That's awful. I'm sure that's a very stressful environment to be dealing with. Um, the best things to do are to keep records. Contemporaneous records are important if it does end up being something that you need to pursue, whether internally with HR or externally with counsel at some later point. One of the easiest and best ways that I find or recommend to do this is to send yourself emails, because emails are time stamped. So when something happens that you consider to be notable between you and these coworkers, send yourself an email describing the event at the time that it happens or within a couple hours, and that way there's no sort of like writing in a journal type of reporting to yourself, because that obviously can be altered in a very different way or could be arguably altered in a different way. um, if it's getting to a point where you're feeling like it's toxic, it's a good idea to go to HR and make a report. That being said, it's important for everyone to also always understand that HR is an employee of the company. Their sort of role is to help safeguard the company from human resource issues. And that includes up to and including litigation. So if their role is to safeguard or be a shield to the company with respect to some of these issues, um, you should just always be cognizant of that in any time that you're speaking to HR about, um, you know, issues such as this, because as much as there's great HR people out there, and this is not meant to bash them, as much as they are, seem to be on your side, ultimately their allegiance is to the company. They are not hired by you, they're not paid by you, and their role is to protect the company from things like litigation, by resolving the issues themselves and to the extent that they're able to do so. But also, what that can mean is that your interests are not the ones being protected. So if you feel like it gets to a point where you want to report it to HR, it might be a good idea to speak to counsel um, first, to sort of have a plan of approach and have an idea about how you want to go about that, in order to best protect yourself. That being said, another thing to do is to, I said contemporaneous notes and reporting to HR. I mean, I don't know sort of what exactly this harassment entails, but there certainly are other steps that you could be taking to either protect yourself or to build a record. And it also is going to partly, what advice is good for you is also partly going to depend on what you want to have be sort of the final result of any action you were to or possibly were to take. So that's another reason that I would recommend that you speak to somebody in our office, so they can sort of get more details about what it is that is going on with you, what your goals are. Do you just want everything to stop? Do you want it to just be addressed by HR properly? Do you want an investigation done? Do you want to, potentially, depending on whether or not there's substantial evidence to support it, allege a constructive termination? Are you thinking about alleging a constructive? And if that's the case, what do you need to do between now and that point in order to best build sort of your record of evidence, so that that's actually possible when the time comes or when it makes sense for you to do so? um, if it makes sense for you to do so. It's not always a possibility. So, Kim, I would suggest that you contact our office and set up a consultation with somebody, in order to sort of parse out some of the details and sort of what you're looking for and what you would like to have happen here, because that obviously is going to impact whatever advice, and also you can speak more clearly about record building and what's possible for you. The last thing I'll say is, if these are coworkers that you deal with directly on a regular basis, um, these interactions are primarily happening when you're working with them in person or interacting with them in person, one good idea is to try and transition as much as you can into writing, um, and work work that way so that any interactions are, there's a record of them and it's registered and so on. As I said, sending yourself contemporaneous emails is fine as well if there are in-person conversations. Taking detailed notes via an email to yourself, about things that happen during phone calls is a good idea. I don't generally recommend recording anything, unless part of the issue is things like slurs and, the things that are being said that maybe need to be heard, but that in any event is not really a recommendation. I think that it's extremely risky to be recording in the workplace, unless absolutely necessary. So I would certainly start with building your record in various other ways, first. Carrie from YouTube said, "My sister was let go from her job, but it was because her coworker blamed her for issues on the job and it wasn't true. Would that be considered a wrongful termination?" So there's a bit of a misconception about what wrongful termination actually means, just generally. So, a wrongful termination does not mean that you were terminated without cause. Um, it means that you were terminated without being paid the appropriate amounts that you're entitled to at law as a result of termination. So what amount that is depends on the common law as well as the statute, and what your entitlements would be under either one of those. And it also depends on what your contract of employment says. If you are paid appropriately in the context of those three elements that have to be considered, then it's not necessarily a wrongful termination. You don't have to be given a reason for your termination if it is a without cause termination. You could be the best salesperson at any company and they could terminate you for no reason at all and never give you a reason. And that's okay as long as you're paid properly. I mean, it's not okay. I know it doesn't feel okay, but it's not wrongful, in the legal context as long as you're paid appropriately. What we're talking about when we're saying a wrongful termination is that you've been terminated for whatever reason, and for whatever reason, you haven't been paid properly. What you're entitled to under contract, common law, and the statute. So when those situations come into place, that's when we're really speaking about wrongful terminations. Um, it could be a wrongful termination if she was terminated for cause, received nothing, and what happened does not amount to cause. It's difficult for me to tell, just based on what you're saying here, whether or not she was paid anything or so on. So I would certainly recommend, Carrie, that your sister speaks to somebody in our office to discuss sort of the particulars of her situation, and hopefully that will give her a bit more insight into what her options are. So that's all for today, everyone. Thank you so much. Our next live session is 2 sessions on Thursday with Jeremy Herman at 1:30 p.m. Eastern Standard and Sandy Chen at 1 p.m. Pacific time. And other than that, we'll see you in 2 weeks. Have a nice day.